We've had the advantage of hearing from Professor Rogerson, who discussed the Moog decision and some of the aftermath. One of the people responsible for the decision in the first place is our next speaker, who was counsel for the intervener. And to tell us how she did it, I'm very pleased to call upon Helena Orton to give us the inside scoop on the intervention by leave. Helena?
Good morning. I'm very happy to be here and see a lot of my old family law colleagues from Ottawa and many others. I'm told that one of the contributions I can make today is to clear up the pronunciation of the names of the parties in this case. I can tell you that in the court they were referred to as Mr. and Mrs. Moog, so I think you can safely use that pronunciation from now on. Now, as Carol has talked about, in Moog, the Supreme Court of Canada was required to choose between interpretations of the Divorce Act, reflecting contending models of spousal support. There had been quite a controversial and active debate about the fundamental question of what is the purpose of spousal support, and that debate arose out of a number of significant developments over the last few decades. One was divorce reform, which allowed for the termination of marriage more easily and recognized that marriage was not necessarily a commitment for life. Significantly, a relatively recent but growing body of social science literature that documented the the significant poverty of women following separation and divorce as compared to men, and the ways in which divorce reform may have contributed to this, or at least failed to fulfill any potential to do anything about it. Also significant was evolving notions of equality and what this concept would mean for formulating spousal support entitlement. And finally, we of course saw many developments in the case law and also the reforms to the Divorce Act in 1985, which set out specific objectives that the courts should look to in awarding spousal support. Now, Carol Rogerson this morning reviewed some of the theories of spousal support that we saw coming out of the case law and that was reflected in the criteria found in the new provisions of the 1985 Divorce Act. And she referred extensively in her discussion today to a theory of spousal support really based on income security, that marriage in itself can provide some basis for entitlement to support post-divorce. No one should be left in impoverishment. And alternatively, a compensation model where spousal support is seen for compensating for the economic consequences of marriage for the husband and wife, and particularly the consequences for income earning capacity. But another significant model that didn't get so much discussion this morning was the self-sufficiency model of spousal support, where support was seen primarily as a basis for allowing the parties to become self-supporting. And in many cases, we saw a clean break model where the emphasis was on cutting the economic ties between the parties as quickly as possible to allow people to go their separate ways. So it's quite interesting that post-Moog, the debate, as Carol is framing it, is more need versus compensation models, whereas prior to Moog, the debate really was more self-sufficiency and in the context of Mrs. Moog's case and Mr. Moog's case, compensation and the extent to which the consequences, the economic consequences of marriage would be fully or partially, to what extent it would be recognized in spousal support awards. Ultimately, as we know, the court in Moog adopted a doctrine of equitable sharing of the economic consequences of the marriage. And this policy choice is having significant implications in making the law more responsive to the economic consequences of marriage, resulting in more generous awards for many women. But the decision is equally important for its methodology. And I want to spend some time talking about that today. In addition to being shaped by traditional approaches to statutory interpretation, the majority decision in particular was shaped by a fairly clearly articulated concern to recognize and respond to the poor economic status of women as compared to men on separation and divorce. The decision examines extensively the social context in which decisions about spousal support are made, and then focuses on equity, both in the results that are attained post-divorce in a particular marriage, and also more broadly in society. Those two pieces, focusing on social context, driven by a concern about equity or equality, is something that we've seen reflected in a series of decisions since the coming into force of the Charter, and particularly the equality provisions. In these cases, statutory interpretation or the common law is developed in a manner that, in a contextual manner, the court examines social context and then develops the law in a way that is designed to make it more responsive to the lives of women as well as men. Now, my paper examines why this kind of contextual legal analysis is not only appropriate but required by the Charter, as well as examining what an equality analysis might mean in spousal support law. However, I want to warn you that probably minutes after I sent my paper off to meet the last final deadline, I think the Supreme Court of Canada released its decision in two cases, Young against Young and DP against CS out of Quebec. And these cases deal with custody under the Divorce Act and the implications of the Charter Guarantee of Freedom of Religion for custody determinations. Now, according to that reliable reporting service, the Globe and Mail, the majority of the court decided that in the Young case that the Charter was not applicable to family law cases. I'm happy to say that I've now read those decisions, and contrary to what is now probably popular belief, family law is real law, and the Charter remains very relevant to it. And as a result of that, I think the kind of methodological and equality-based analysis that was a significant factor in shaping the Moog decision is going to be important to family law practitioners, both in dealing with the aftermath of spousal support following Moog, but also with respect to other areas of family law. So what I want to do is go through some of the analysis and factors that went into Leaf's submissions in the Moog case. As I already mentioned, the Moog case occurred at a time when there was an increasing body of social science data documenting the high poverty rate and other forms of economic disadvantage of women and children following separation as compared to men. Leaf intervened in large part to bring this information to the court in order that the court had some evidence about this social context in formulating its interpretation. I think it's worth briefly reviewing some of that data. In a 1988 study completed by the Department of Justice, 46% of divorced women had total incomes, including employment and support income, below the poverty line. In contrast, only 13% of men who paid support had incomes which fell below the poverty line, and the average income of male one-person households after marriage breakdown was significantly above the poverty line. As the majority in Moog recognized, a major factor contributing to women's economic disadvantage on separation and divorce historically and today has been the differential work patterns of women as compared to men during marriage. And despite significant increases in women's labor force participation and a greater diversity of marital relationships and so on, women continue to be primarily responsible for the work of homemaking and childcare. The consequences of the dual responsibility of childcare and paid employment are quite significant. Women have significantly curtailed their employment through interrupting employment or working part-time, or made sacrifices in the course of their employment by forgoing skills upgrading, promotional opportunities, refusing job transfers, and so on. The Moog decision goes through fairly comprehensively the kinds of consequences that this has, and refers to a number of studies that are now available that document the general economic picture. The particular general problems that women have, though, are often compounded by other kinds of social inequalities. For example, in the case of Mrs. Moog, she had immigrated from Poland in the 1960s, and her ability to improve her English was limited by her responsibilities for home and family. And so those kinds of other inequalities are also factors that have to be taken into account in assessing the degree of economic disadvantage that flows from the marriage. The consequences are broad, and the data shows that they are quite a bit more significant than was reflected in the case law previous to the Moog decision. Now, it's important to ask why it is that it's almost exclusively women who make these kinds of employment sacrifices and therefore are in the position of needing spousal support. Is it simply a matter of women's choice or the family's choice, or are there other forces at play? Obviously, the answer is multifaceted, but a critical factor is past and current social structures. Canadian society continues to be organized around a gender-based division of labor during marriage. Child care and domestic work are largely treated as a private responsibility, and so the work world has been generally unresponsive to family needs, historically having been structured on the assumption that there is a wife at home. In this context, then, one can see why the choice to remain at home is often not a real one. Because of inequality in the workforce, it's often economically rational for the family unit that the woman stay at home rather than the man, or sacrifice her employment opportunities in some way. So as long as these societal structures continue in place, it is likely that women will continue to be significantly economically disadvantaged on marriage breakdown. Now, that is a consequence or an analysis that doesn't specifically isn't specifically reflected in the Moog decision, but we do subsequently see accepted by Laura DeBay in her decision in the Young decision. So it's an analysis that's important to keep in mind, and it is relevant to a variety of family law issues. Now, a critical question that arises at this point is who should bear the economic cost on divorce of meeting family needs through a gender-based division during labor? Should it be the woman and the man, or society? In other words, what is the role of family law in addressing this economic disadvantage? Now, from a social policy point of view, one of the significant factors that affects the answer to this is the capacity in most families to fully address the economic consequences. In a study done by Marguerite Eichler of Toronto, she pointed out that even if principles for awarding spousal support are significantly more generous, it won't take the majority of women out of poverty following divorce, because there simply isn't the financial resources in many families to pay significant enough awards. The important message here, I think, is that there's a real danger in over-relying on family law solutions to address women's poverty. That from a broad social policy perspective, it's extremely important that change continues in other areas in changing the organization of the workplace to accommodate family needs, employment and pay inequity, child care, and also the reform of government income security systems. On the other hand, both Marguerite Eichler and the majority in Moog recognize that family law has an important role to play in addressing these economic consequences, in achieving greater fairness in individual marriages, and also more broadly in achieving a more equal society. Now, the goal of sex equality has been historically an important guiding principle for reform in many areas of family law. It's influenced reform about who can obtain a divorce and when, principles for division of property, and in other areas. On the basis of equality principles, spousal support became available to men as well as women. We have also seen the obligation to become self-sufficient as a primary goal of spousal support justified on the basis of equality principles. A common analysis that can be seen in the majority decision of Moog in the Manitoba Court of Appeal deals with non-traditional marriages. And the majority said that society is changing, women have the right to equality, and therefore women should not be dependent on men, and women should have the same obligations as men to be self-sufficient. And as a result, they concluded self-sufficiency ought to be the general rule in, quote, non-traditional marriages. This type of equality analysis it reflects an understanding of equality which requires that men and women be treated the same. However, with the coming into force of Section 15 of the Charter and important developments in human rights jurisprudence over the last couple of decades, we've seen major evolution in the concept of equality, of what equality actually means. The Section 15 guarantee of equality is obviously quite young, and interpretations are going to continue to evolve, but we have seen some fundamental principles established about what equality means for purposes of Section 15 and more generally in Canadian law. The first decision of the Supreme Court of Canada to deal with Section 15 of the Charter in any depth was Andrews against the Law Society of British Columbia, which was decided in 1989. And as in the Moe case, the court was faced with a number of competing theories, in that case of equality. In the Andrews case, the court rejected the similarly situated or same treatment model of equality. The similarly situated approach says that the concern of equality is that likes be treated alike and that those who are different may be treated differently. It's often referred to as a formal approach to equality because it's not focused on addressing the existing inequality experienced by socially disadvantaged groups. It is also considered to often perpetuate inequality because because of what are perceived to be differences between groups in society, and also because it leaves intact existing social standards which have long been considered neutral but tend to reflect the characteristics of more socially advantaged and privileged groups. In the context of sex inequality, the formal approach to equality is not terribly useful for women to the extent that women's lives don't have any comparison with men's, such as in the areas of reproduction, sexual assault, and violence against women, and also in the area of homemaking. In the Andrews case and in subsequent cases like Turpin and Schachter, which are discussed more extensively in my paper, the court, as I said, rejected this same treatment model of equality and adopted an approach to equality that is more focused on the substantive concern of eliminating inequality experienced by groups that are socially, politically, and legally disadvantaged. This is then often referred to as a substantive equality approach. What this jurisprudence makes clear is that equality is not about same treatment. Equality will sometimes require same treatment, but on the other hand, same treatment or pure symmetry will actually often impede the achievement of meaningful equality. Now, because of problems of access to the courts among disadvantaged groups, most equality jurisprudence remains at a fairly abstract level. However, as I've mentioned, one of the most interesting series of cases post-charter arises in cases where equality rights are not directly in issue, although charter values, particularly equality values, play an important role in the development of the law. In these cases, the court takes a contextual approach. It looks at the broad social and economic context in which a legal problem arises and uses that information in order to develop the law in a way that is more responsive to the needs of groups, particularly women in these cases, whose realities have not been particularly addressed by law in the past. The court hasn't tended to specifically root its decisions in the charter. Instead, it tends to state that the decision is guided by a public policy to avoid inequity. Developing the law so as to be consistent with charter values is not new. It's now quite well accepted that charter is the Supreme Court law of Canada, and accordingly statutes have to be interpreted and the common law has to be developed in a manner consistent with the fundamental values enshrined in the charter. As a result, while the Supreme Court of Canada has decided that the charter will not apply to an action between two private parties, and therefore, in these kinds of cases, for example, a court order is not reviewable under the charter. On the other hand, the Charter is far from irrelevant in these kinds of cases. Obviously, a court must act within any legislative framework that has been established by government. Where legislative intent is clear, the courts have to apply the law absent a charter challenge to it. However, where the meaning is unclear and where the more than one interpretation of the legislation is possible, then the court has said that the values embodied in the Charter have to be given preference over an interpretation that runs contrary to them. Now, the recent decision of the Supreme Court of Canada in Young and DP that I mentioned earlier confirmed this jurisprudence. In these cases, there was a constitutional challenge to the best interest test for determining custody on the basis of the guarantee of freedom of religion, and the court rejected that argument. But also there was an argument in that case that the best interest test has to be interpreted in a way, the principles of interpretation have to be developed in a manner that's consistent with the value of freedom of religion. And the court all accepted that. The difference in the case was how the court would have applied that value and the extent to which they took into account competing constitutional values in framing a test. Now, I'm running out of time here, but so I'm going to start moving a little more quickly. My paper refers to a series of cases, which many of you will be familiar with. Lavallee, Norberg, and KM, they're all recent decisions of the Supreme Court of Canada. And in all of these cases, the courts have taken a contextual approach to development of the law based on a public policy concern to avoid inequity. What's interesting about these cases is that the understanding of equity is not the formal equality approach that we had seen in earlier case law, but instead a substantive equality approach. So these cases illustrate an alternative kind of role that the Charter can play in the development of the law. I think what's important to the extent that that people think about using this approach, and you can see from the cases, is an accurate and thorough evidentiary base. One of the problems that we saw in family law, for example, prior to the Moog decision, was inaccurate assumptions about the realities of women's lives, which formed the basis of jurisprudence. And what this approach does is require that we don't make assumptions, that we look particularly at what the social science and data is, and look at other kinds of other forms of evidence in order to look at what those realities for, and based on that kind of fact, develop the law. Applying then equality principles to spousal support. This is not a terribly complex area, although but on the other hand, I don't want to run through it too briefly. I think the issues that Carol raised this morning point to the different kinds of visions of spousal support we can see beyond a self-sufficiency kind of model. The focus of Leaf in the Moog case was to encourage the court to take into account the realities of the consequences of marriage post-divorce for women and men, and that in interpreting these provisions of the Divorce Act, the objectives of economic advantage and disadvantage, compensating for those factors, are something that has to be a critical focus of spousal support. This is not to say that it is the only focus, but it's a focus that equality principles, substantive equality principles mean cannot be subordinated to other social interests like self-sufficiency. Now, clearly, we all have misgivings about abandoning a needs-based model of spousal support, which is the sorts of issues that that were raised in the case law that Carol discussed earlier this morning. These are very important issues. An equality framework is not the only framework for deciding these issues. Ultimately, the court has to look at the legislation. But from a social policy point of view, I think one of the critical things that we all have to be looking at then is, given the modern social context of family law, who should be picking up the burden in those sorts of cases? Should it be the family or should it be the state? Of course, we don't have adequate income security systems at the moment to play that role. That's the dilemma, and that may be why the legislature, the parliament left open a greater continuing role for a needs-based model. Very briefly, the kind of contextual equality-driven analysis that we saw in Moog clearly is going to have implications for other areas of family law. Carol referred to the Peter and Beblow case this morning, which is already one example of how the specific doctrine of equitable sharing can be applied. If you look carefully at the Young decision dealing with custody, you will also see reference to the same sorts of contextual issues. It's clearly going to arise in a number of areas. I think one of the interesting areas where we're going to see arguments soon deals with the variation of the provisions for spousal support in final separation agreements. In Pellick against Pellick, the court said that the overriding policy consideration in these cases should be encouraging parties to take responsibility for their actions and get on with their lives. If we look at the social context, though, of deciding what approach we should take to final separation agreements and spousal support, we see a reality where there is a strong pattern of women bargaining away support entitlements which are designed to address their economic disadvantage. In this social context, combined with inequality of bargaining power for both social and economic reasons, one therefore has to question whether legal theory which favors freedom of contract ought to, stemming from a very different type of context, ought to be given priority over the concern to equitably share the economic consequences of marriage set out in Moog. So clearly there are going to be some very interesting days ahead, and I think that you will see that the types of the methodological approach in the equality analysis that was so relevant to the court's decision in Moog is going to be popping up in many other areas of family law. It's one that not only do you need to be prepared to deal with, but in serving your clients, you can often do well to develop in your own cases. Thank you.
Thanks very much, Helena. We're now going to have a panel that will try to pull together some of the questions and hopefully the answers to the issues that we've heard discussed so far. Evlyn McGivney is the moderator of the panel, and I will ask her to introduce the panel members to you. Evlyn?
Thanks, Jim. On my far left is Linda Silver Dranoff of Dranoff and Associates. Next to Linda is Malcolm Kronby, who is with Macmillan Binch. And last but not least is Stephen Grant from Gowling, Strathy, and Henderson. Each of these parties, I'm not speaking about their ages or their other seniority, but they've been practicing, I would venture to say, at least 18 years, some of them more than 20. What we're going to do is attempt to approach the issue of support from a practical perspective, that is, from the practitioner's point of view. If your client comes in and asks you how much support she's going to get, or your client asks you how much support he's going to have to pay, you probably are not in a position where you can move on with a case that will end up in the Supreme Court of Canada on principle. So while we appreciate the models, et cetera, and we will discuss them and make some comments about it, we will be viewing 2 or 3 fact situations and hopefully giving you some practical response to the claims that are being made. Now, we'll refer to Moog and Elliott. I'm glad I know how to pronounce it now. That's Moog. And thirdly, to the decision of the Ontario Court of Appeal in Robinson, which I thought was in the material, but it isn't. It should be, and hopefully it will be delivered to you later. This was a decision September 24th, 1993, prior to Elliott. A decision of Madam Justice McKinley, Mr. Justice LeCourcier, and Mr. Justice Carthy. Madam Justice McKinley wrote the decision. I'll just give you the facts quickly. The parties married in 72. They adopted a child in 75, separated in 85. Both had the same earning capacity. However, the wife decided to stay at home and take care of the child and had given up her employment. They had a very comfortable lifestyle and used the husband's inheritances both to buy their home and to support their lifestyle in London, Ontario. After the marriage failed, the wife tried to get into law school and did not qualify. She finally moved to Toronto with the child, and she lives with her sister in a home which is primarily financed by her family. At trial, one more thing, the wife took a lower paying job than the court felt she could have had available to her. At trial, there was child support of $1,500 per month, and there was no interference and appeal with this. Spousal support was $1,000 a month at trial. On appeal, the court found that the economic effects of the marriage were negative for both of them. She had benefited from his inheritance. He had lost by putting his inheritance in. Therefore, they basically felt that she had been primarily compensated for her economic disadvantage. It was not his obligation to top up her earnings, to use the court's phrase. The Court of Appeal ordered spousal support of $1,000 per month until October of '93, which is last month, reduced to $400 per month for 5 years, and then zero. Okay, just so you have a sense of those facts. Now, Linda, we're going to go back to Moog, Elliott, and Robinson. Linda, given the decision in Moog, can you tell us what the present support model is?
Now, tell me, which case in my office are we talking about? I guess it's not any easier for me as a practitioner than it is for any of you in figuring out how to apply Moog in any particular case, in any particular circumstance. Because I think really what it's done is opened the field wide open, except what Moog very clearly stood for is a disregard of the economic self-sufficiency model to the extent that it was being applied in the past. I mean, the case really did stand for a lack of regard for the causal connection line of cases, and said that basically compensation was the model, as I read the case, but against a backdrop of needs and means. Needs and means are always going to be a factor. And I think that when you read the Court of Appeal decision in Elliott, it confirms that perspective, that while compensation, the compensatory model, was seen as primary in the Court of Appeal decision in Elliott, the basic question asked by the Court of Appeal, which of course any of us who've practiced law, family law for many years always hear, is, well, can he afford it? In the final analysis, the Elliott case, in some respects, showed us that the means of the husband is always, the payor usually, is going to be a very significant factor. I think that the self-sufficiency model, however, will still occasionally be applied, but I think it'll be in much rarer circumstances. I think that much more often it'll be compensatory against a backdrop of needs and means. I think the Robinson case that Evlyn referred to, I hope it's an anomaly, because I think it really was a clean break decision for reasons that to me were inexplicable reading the Court of Appeal judgment in the case. I didn't understand why the court in that case said that the amount for this particular woman would be reduced and then it would be terminated in 5 years. I thought termination dates went out as an automatic thing many years ago, certainly without serious justification and serious review. However, here we have a case in Robinson that referred to Moog very briefly, and then turned around and said, applied in effect a clean break model. The case could have been written 10 or 15 years ago as far as I was concerned, and in terms of principles basically ignored Moog. So does this mean that Moog will now stand for anything the judge wants to do in his or her discretion is open for grabs? I mean,
Okay,
I wonder-
Linda?
Have I talked too long?
No, just long enough. Malcolm? Your turn. Malcolm, can you tell your clients what they can expect in court for spousal and child support?
Yes, of course.
Will you be right?
Sometimes. If we start with the idea that there is a large ambit of support within which reasonable people can agree or disagree, we understand, all of us understand, that there is no one magic number. And any of us, I think, with the experience that we bring to these matters, can establish a range within which support would be awarded. So it's not a number, first of all, it's a range. Now, when we're applying the different support models and the different principles of law, it's clear that we have an amalgam of legal principles that can be applied. We know that in Moog there is, as Phil Epstein accurately put it, something for everyone. If you haven't seen his paper done for the Canadian Bar Association last January, you should. There are 27 points that he takes out of Moog as something for everyone. The Moog case says in part there are no easy recipes, so perhaps it's not an amalgam at all, it's an omelet. It's an omelet of law. There are 4 eggs that go into this omelet, whether they're under the Family Law Act, Section 33.8, or under the Divorce Act, Section 15.5, and they are scrambled. You cannot unscramble them. What you know at the end is you're going to get an omelet. What you don't know is whether this is going to be an omelet filled with, say, caviar, or whether it's going to be a plain omelet, or a frittata, if you like. The point, you see my point though, you know that something is going to emerge here. You just don't know, you don't know how rich it's going to be. So in a given case, there may be a filling, all right? Based on somebody's particular contribution, based on the idea that there is something that needs to be redressed or compensated. But clearly, you can't isolate any one element of law, and you can't unscramble the omelet. So you've got to bring your judgment to it. And what does that come down to? Well, I think it comes down to old-fashioned principles, such as need, because both statutes, both the Family Law Act and the Divorce Act, talk about need, and means, capacity to pay, standard of living, and all of the things that you would reasonably bring to bear upon any case that faces you. And then you get a range. It's a high range or a low range. Somewhere within the envelope is where the court is going to make an award. Now, isn't that simplistic?
It's old-fashioned.
It's simple anyway.
Yeah. Okay. Stephen, is the award in Elliott compensatory support?
That's a good question. The Elliott Award, I think, has a compensatory element. If you take Malcolm's omelet or frittata analogy, it's like putting the onions and green peppers on top of a needs-based approach, I think. And in considering what I think a court is going to look at, just to digress for 1 second and answer the first question, it seems to me that the phrase that we use in separation agreements, or we've seen in variation clauses in agreements, the pattern of economic dependency arising from a marriage or relationship, I think is the key, and how you address that or redress that is what the amalgam is of these various models. I think if we start looking at models or thinking in terms of models apart from the abstract exercise of seeing what the courts are doing in practice is a bit illusory. I think where practitioners have to start from is the idea, is there a pattern of economic dependency that has arisen from the relationship, and how do we address that after a marriage breakdown? In Elliott, it seems to me that the court did recognize a compensatory element to it. What the court didn't like, maybe this is an understatement, the court didn't like the idea of a lump sum. And but the court, I think, in fairness, recognized that Mrs. Elliott had sustained a serious economic disadvantage or dislocation arising from the decisions that had been made in the marriage, and were prepared to compensate her for that on an ongoing basis. You'll note in Elliott, as in contradistinction to Robinson, there was no time limit. There's no time-limited factor in Elliott. Robinson, they clearly emphasized and awarded a self-sufficiency end to the award of support, which they didn't in Elliott. So you can look at compensation in any number of ways. You can look at the quantum of the award, which may or may not be appropriate in Elliott, but the Court of Appeal says it was. And you can look at the duration of the award to say that that adds a compensatory element. So yes, the answer is I think that there was a compensatory element. It wasn't the way that my colleague Joe McLeod and I thought it should be awarded, but they're the Court of Appeal and we're not.
Okay, Malcolm, when I analyzed the numbers in Elliott, what the court appeared to do was decide, or the parties had agreed what the child support need was. So that number wasn't an issue. Mm-hmm. The court had $80,000 of income to divide. They ended up giving Mr. Elliott $30,000 and Mrs. Elliott $50,000. But if you analyzed the compensatory support that they ordered for her and then looked at the child support need, in fact, Mr. Elliott ended up with more of the net income than the court really said Mrs. Elliott needed more. She needed $56,000 of the $80,000. She didn't need $50,000. So in sort of moving the money around a bit, Mrs. Elliott ended up, I think, really losing the compensatory support. They gave it to her in some way, but then they took it out of the child support. So she ended up with less than she needed. So one of the questions I have is, if Mr. Elliott had a lot of money, Malcolm, would they have ordered the lump sum payment?
Well, that's a very, very good question, because the Court of Appeal, in recalculating the amount of income loss or future economic loss, chose a model different from the one taken by the trial judge. They moved that figure up by something more than double. Having moved the figure for future economic loss up to $236,000 net of tax, and you'll remember they said maybe tax shouldn't have been taken off. But anyway, it gets up to $236,000, and then they say, well, he can't pay that amount of money. It just shows how silly this whole thing is. He can't possibly pay a lump sum that large. But they leave wide open the question, well, what if he could pay a lump sum that large? I mean, what if Mr. Elliott had $500,000 lying around in a checking account? Would they then have said, okay, pay the lump sum, whatever the amount may be? It's really an open question and a possibility. And where I think we may find this arising is in a claim under the Succession Law Reform Act, where I think it's open to the court to make the same kind of support awards as it can under the Family Law Act, but where in the nature of an estate, there's likely to be an asset pool or a lump sum available to satisfy it, and of course, considerable motivation for creating a clean break. So I doubt if we've heard the last of this one.
Could I comment on that? I think that part of the difficulty here is that there is an equalization payment or difficulty or benefit. And once there's an equalization payment, are we then going to see apportionment of capital beyond the equalization payment? In a succession law reform situation, given the right to elect to have the same half share as is available under the Family Law Act, I would think the same principles would apply to the Succession Law Reform Act situation as would apply under the Family Law Act. The question then becomes, is there going to be an apportionment of capital beyond the equalization payment? And probably I would say that relates better to how much there is there and what all the other circumstances are. I would think that it wouldn't happen very often.
Stephen?
That question that Evlyn asked Malcolm is very interesting. If you take the Court of Appeal literally in the Elliott decision, they say that the compensatory element has to be paid out in the way in which the loss had benefited Mr. Elliott in an earnings or an income stream. So if you take that statement literally, it wouldn't matter how much Mr. Elliott had. Mrs. Elliott wouldn't get a lump sum. I mean, that's the literal reading of that. Now you say, well, maybe that shouldn't apply or shouldn't. It doesn't really make sense. But it struck us that the Court of Appeal simply does not like awarding lump sums, and they refer to an earlier case of Malcolm's. What was the name of that case? McMillan, in which they struck down a lump sum must be 5 or 6 years ago now for similar reasons. They simply don't like using the lump sum vehicle. So I'm not sure the answer to that question is yes.
I want to move on to a fact situation. We have 2 or 3 fact situations. I'll briefly tell you the facts, and then we will view them from a practitioner's perspective as to what you would expect to receive for your client. In this first case, the parties were married for 15 years at the time of the marriage breakdown. From the time of the marriage forward, the 2 of them were doctors. They were well educated and had their own private professional practices. The wife gives up this partnership, however, and begins to work only part-time after she has had 3 children during the marriage. The husband has continued on his career path. The wife has full-time live-in childcare. After equalization, the wife will have a small amount of capital, $300,000 or $400,000, which will allow her to have a home. The husband will have roughly the same. The wife now earns, we're not in Toronto, okay? The wife earns $50,000 a year in her part-time practice. The husband earns $400,000. Okay? If the wife was working full-time and had the same opportunity, she would be in the same position as the husband now. Okay? She doesn't want to work full-time. She has 3 children, 11, 9, and 7, and she wants to be there for them for all participation in their upbringing. So she doesn't want to work on any other basis than she is now for approximately 10 years. The child expenses are agreed at $6,000 a month gross, including the income tax, and the wife in her financial statement has total expenses of $10,000. That's including the children's, gross before tax. The husband offers to make up the difference of her needs. Okay? He's going to give her $70,000 a year in child support. First question is, will the court order spousal support given the husband's position of making up the needs? Anyone?
Well, I start with the idea that if she's expressing her need at $10,000 a month gross, including tax, which, with respect, is unlikely on the income level that you've given us here. I mean, total family income of $450,000 a year. It just doesn't sound right. But if that's what she says she needs, and it's her expression of her requirement in order to maintain something approaching the established standard of living, my sense is that a court will give her what she needs, what she's asking for.
What if it's twice that?
Well, it could well be on the income numbers that you give us.
Will they give her that as well?
Well, I think what you're saying is, if I may paraphrase the question, if a wife is earning $50,000 a year, is there any way she's going to get child support on top? Is that a fair paraphrase?
Spousal support.
What did I say?
Child.
No, spousal support, of course. If she's earning $50,000 a year, can she get spousal support on top of that? The answer is, of course she can, if that's the need and there's capacity to pay.
Okay. Is it appropriate for her to continue the 10 years in this position raising the children? Does she have, quote unquote, a right to do that? Should she be back out at work knowing what capacity she has to produce income, given that she has childcare and can afford it?
I don't think that's the right question with respect. I think the right question is...
Don't correct my question. Just answer it.
Right. The answer is yes.
What was the question?
It seems to me that the question was, does she have the right to stay out in the workforce or out of the workforce on a full-time basis for 10 years? Surely she has a right to stay out of the workforce on a full-time basis for as long as she likes.
And expect support.
Well, the question is, what will the court do about that? If they like this woman as much as they like Mrs. Robinson, she might as well start thinking about full-time work today or tomorrow. But it seems to me that if Robinson is read appropriately as a drive towards the economic self-sufficient model, if you will, then it seems to me that they will phase in this client back into the workforce on a fixed or time-limited basis. What is interesting about Robinson, I think somebody mentioned it earlier, is how we are. If Robinson stands for a general proposition instead of on its facts, we are looking again at some kind of time-limited support, which is an odd thing. The other thing you might want to note is that we have seen on a couple of cases the return of the nominal support order, and I was thinking in this case that if you time limit her support and bring her back into the workforce on a full-time basis, say when in a couple of years rather than 10 years, you might see a nominal support, a dollar support award to take her on after that.
Can I comment, Evlyn, on this concept of her needs? Malcolm is continuing what he said earlier about needs and means being the model, and if she only needs $10,000 a month, that's all she should get, and that they wouldn't only be spending that amount if the husband earns $400,000 and she earns $50,000. But what this may mean is that this is a family that actually saves. Maybe some part of what he and she doesn't spend gets saved in register retirement savings or other forms of saving. So the question is, once the marriage breaks down, why shouldn't she be entitled to save in the same way that he would be entitled to save? If he only pays her what she needs to top it up to the $10,000 a month, he's going to have a significant amount of money to put aside for himself, for his future, and she won't have that. She will instead be home taking care of the children. So I think that we have to look at needs in an expanded way. I would like to suggest the solution that I would suggest that a court would order in this case. I can't answer the question by saying the court would order it, but I would suggest that in this case the court simply equalize their incomes and then require them to contribute equally to the support of their children in the amount that's been quantified, which is $6,000 a month. Then each will be able to save, each will be able to contribute equally to the support of their children, and the husband will pay his fair share, in effect, for her taking the time off from work to raise the children. Now, I can't say, depending on which court and how the matter were framed, how it would be answered, but I would hope that it would be answered in the affirmative, given the Elliott case, which talks about sharing the future income stream.
A comment on them, if I may. I think Linda makes a very good point. We got to get our courts past the idea that spousal support is not to be used to create capital. There's a considerable thread of authority to that effect. So given a compensatory support model, perhaps we can advance the thinking to the stage where our courts will say, yeah, it's not unreasonable that the dependent, let's say the wife, should have enough surplus that she can contribute to an RSP as well, or contribute to her future security. But there's a question. May I put a question to the audience, please? When you read the Robinson case in the Court of Appeal, one of the astonishing things about the judgment is it doesn't tell you what the income of the parties is, and it doesn't tell you how much the equalization payment is. So it's pretty hard to correlate it to a practical fact situation. Does anybody here know personal knowledge from that case? Okay.
It also doesn't say so in the trial level decision,
Yeah.
which I looked up, which
Yeah.
is from 1989. Nobody says how much the husband's earnings are in it.
Mr. Shaughnessy's up here in the corner. On the case, maybe you can fill us in.
Ah,
I'm only an
That was for each of them?
Yeah, the matrimonial home was said to be worth $243,000. I see.
His income?
How much did they earn?
No, he didn't include it. I looked it up. It's not in that judgment.
Couldn't find it.
$88,000. But he'd only been in that job for 9 months.
And the wife in her unskilled job at Hydro, do you recall that?
She was earning about 24.
Okay.
And she got $400 a month, time limited.
Scary, eh? Now, Linda raised the concept, which I thought was interesting, of the equalization of the parties' incomes. And I wanted to ask a question of the audience. How many of you believe in your, given your experience in your practice, that the court would equalize these incomes? See a hand? In the facts that we've just been discussing, the 400,000 versus 50. Do you think there's even the slightest hope you're going to get an equalization?
Are there any judges here who could comment?
Who thinks that concept is fair? That is, you divide the total family income in half, and then you make each of them contribute to the children in an equal manner. Okay, it's interesting. It's interesting.
Overwhelming majority, I would say.
Don't think it's fair that happened. Yeah. Now, I have another question I want to ask the panel, and that is, will you quiet down, please? Does it matter why she left her full-time practice of medicine? I.e., was she asked to leave by her partners because after she had the children she wasn't carrying her weight? Did she choose to do it on her own? That is, she just decided she didn't like practicing medicine all that much and would rather be at home. Was it a joint decision of the parties? Does that matter when we're coming down to the spousal support issues? And the reason I ask that is virtually every person who is met with a compensatory claim says, I didn't tell her to stay at home. I wanted her to work. This was her own decision. She's had a great lifestyle. It's time she got up off her and worked like I have for the last 15 years. Okay, so Linda?
Oh, I don't think it matters because however it arises because of a division of responsibility in the marriage. It's the fact that she has to take care of the children, whether she decides, they decide. Somebody's got to take care of the children, and in this world that usually, or most often, ends up with the mother, although in some cases with the father, but let's be realistic.
Steve? She had full-time live-in nanny. What was she doing all day? You know? That's the question, isn't it? Yeah.
Somebody
That's exactly
has to
what's
supervise.
asked in these cases. Stephen?
I don't think it necessarily should matter why she left, but both Elliott and Robinson suggest that the court will want to know why she left, and it may have some bearing on the nature of the compensatory aspect of the support award. If my colleagues here are right that we should be looking at enlarging the concept of need to include things like savings and RSPs and so on, which could in fact be considered a compensatory element, then I do think the court will want to know why she has left the partnership or the business that she was in, and why her plans have taken her to the point where she isn't planning to return for a certain period of time.
Malcolm?
I think they want to know, doesn't this have something to do with possible economic self-sufficiency or how far you've advanced in your career, stuff like that? Even if it doesn't apply at the highest judgmental level, I think it influences the court. I think it influenced the court in the Robinson case. The fact that she had a pretty good education and the husband had supported her. Let's remember in Robinson, the husband had paid support voluntarily and then under an interim order from about 1985 until the case got to trial, and I suppose he was still paying it when the case was in the Court of Appeal, paying some sort of a support anyway, when it was in the Court of Appeal. And she had, with her education, she'd passed up employment in London in her chosen field. They make a point of mentioning that.
She'd moved to Toronto.
She'd moved to Toronto, where
Knowing
the
it
cost
was
of
expensive?
knowing it was expensive. That's right. She had left London and gone to Toronto, and she had taken a job I think they described her as underemployed
Yes.
in her present job. Yeah, I think they want to know. I think it's got influence on the case.
Yeah,
But then,
they
quite
also-
interestingly, the court says her needs hadn't increased, really. She wasn't in great need.
Well, she wasn't in
Having
great
criticized
need.
her for doing those things, they then said she wasn't in great need.
Yeah, but they also knew that she was getting a lot of support from her own family, and I think, again, they don't lean on that,
They
but
leaned
it's
on
in.
it.
But it's in. Well, you say they lean on. Okay, she was living in a house owned by her sister, the purchase of which had been financed by her father. So you get the sense that there was a lot of money somewhere in Mrs. Robinson's background, and the court was responding at some, I was going to say subliminal, but it's not, some lower level. They were responding to those ideas.
And Madam Justice McKinley was clearly, I thought, quite disturbed about the fact that this poor man had used his entire inheritance for this family and that she got half of it. And
Well-
she seemed to have hers out in the future, and it was not going to be shared with him. She
But
made
we
that
don't
point
know-
very clear.
We don't know how much that inheritance was either, since we have Mr. Shaughnessy here. Could you fill us in? Really?
But whatever it was, it went into the matrimonial home, apparently. Oh, her future inheritance, I see.
No, it was his inheritance. How much was it?
Well, it extended over 15 years. It was all essentially used up. The husband earned $30,000 for much of the marriage. There was nothing in bank at the end.
Okay, now we want to move on to the next fact situation.
Amazing.
This situation is a marriage of 20 years. The wife is unskilled, only worked for a couple of years. They've had 6 children. She has been at home through the period of the marriage. Okay. She might be able to earn $1,000 a month if she got a job, but she couldn't afford the child care that would result from her being employed. Her total financial needs are $6,000 per month. The husband earns $90,000 a year, so the wife needs 72 of the 90. Oddly enough. The property, largely inherited by the husband, was split $300,000 to each party. The question is, will the court give this woman more than half of her husband's income?
I hope
Stephen?
so.
Assuming her needs are clearly more than half, will she get more than half?
I sure hope she gets more than half. But the question is whether or not there's a psychic threshold, where there's a ceiling where the court simply won't go beyond, and is that half of the husband's income? Now you say to yourself, why should that be the case? And there's really no cogent answer to that. You would think that on these facts, with 6 kids and a lengthy, long-term traditional marriage, she should get more than half. I would think in this case she would, marginally more.
Okay, so he might end up with 30 of the 90 and she'd end up with 60 or 50-40? So
I think she'll get
70?
something more than half, simply because of the length of the marriage, the number of the kids she's under, and she's has no real skills according to this. She's not. There's no point to her working according to your facts, and I think she gets a little more than half. She probably should get most more than half, but she
Is there
won't.
really an issue here of compensatory support, Malcolm? I mean, this is a traditional homemaker versus the person who gave up the career. Is that an issue at all in this case?
Oh, I don't think so. There's nothing to compensate with here. I mean, or compensate for, as Stephen says. You could say, well, what did she do? Is that what you're saying? All she did was stay home.
She
and
only
make-
raised
No,
three
no.
chi-
No,
6
6
children.
children.
No.
No, what's your point?
My point is that she will not. There will be no time limits on this support. It will be indefinite support.
Oh,
forever.
sure.
And you don't need. And I don't think you need to worry about compensatory support or non-compensatory support. This will be long-term, unlimited support of some quantum.
I suppose so. I guess it would have to be broken down between the wife and children, because you've got children up to the age of 18. Somebody's going to outgrow the need for support, though there's not a hell of a lot of difference whether you've got in total quantum, whether you're allocating support for, say, 3 children or 6 children. It's not going to make much difference.
My only point is that whatever component she gets will be and should be indefinite.
I agree, but there is a cogent reason for not awarding for example, 2/3 of the husband's gross to the wife, although it may appear appropriate on the statistical breakdown. Our courts have consistently resisted making awards at that level. I think they do it because they don't want to drive the husband away. They don't want him to abdicate, quit his job or something. They don't want him to say, well, to hell with it. You know, if I've got to pay 60,000 out of 90, if I'm left with 30,000, I'm not going to continue this work. I've always wanted to write a novel, so I'm going to quit my job, I'm going to write a novel.
That's a disturbing comment, because I've heard that in the almost 20 years I've been in this business. I've heard that comment many, many times. We will not order more than we think he will reasonably pay.
Right.
But I have never had a client, and there are obviously people who default, but I've never had a client say, well, I'm going to stop working as a doctor and I'm going to go to an ashram because you've given more money than I want to pay.
Well,
so
you hear the
I have
comment.
a problem. Well, you do hear the comment,
hear
but
the
that's like
comment.
saying I'll go bankrupt if
Or
I have to equalize.
I'll move.
Yeah.
You hear that comment, it's a real question
So
as to how many do it.
We've given in to that fear all these years with this ceiling that says we don't want to go beyond that ceiling because he might. And I don't know how many do. The people that are going to default, it doesn't matter what order you make against them, they're not going to pay anyway.
Evlyn, I'd like to see, since we have some academics here, I'd love to see a study done as to whether or not, I'm sure you could access the SCOE lists and find out if there's actually any truth to that threat. Because it's true, I've never been aware of anyone who's sort of left his current lifestyle, his job, and the country in order to avoid paying support. And I think that if a study could establish...
Well,
What happened?
there's people in the audience.
Ask the audience.
Yeah? Who?
Okay, audience? How many of your clients, male clients, have given up their jobs and just taken off because of the support award?
How about
Okay? Now, is that because the
I'm
support
living on
is
the right
more
side of
than
the
half the income? Is that, or is it just the person didn't want to pay? How many had support awards more than half the income? See how many there are? Very few. How many of them have taken off? Interesting.
Family support plan told my guy's employer that they would only take a doctor. And
I know they can't take more than that from the pay.
prior to that, he had allowed more than half through some sort of authorization. He just withdrew that. That was his solution. Still getting half of it.
Do the people leave or stop paying or quit jobs because they see it as an economic disincentive or some psychopathology at work? I mean, I don't know the answer to that.
I don't either. Okay, now here's an interesting scenario. The wife has $12 million of exempt assets, so they do not have to be shared on equalization. They're all inherited. The husband is 42 and the wife is 37, and they've been married for 9 years. The husband has earned virtually no income during this period of time, and he says that he sacrificed his career to be a companion to the wife. Interesting, you laugh. Okay? There are no children. The wife earns about $30,000 a year doing charitable work, and she also has another $500,000 a year from her investments. He will end up with about $300,000, which is half of the home, all from this inheritance. He's paid for nothing. Would you award the husband support?
That's really interesting because you see this is a real case. This is a real case, and most of you would not award the husband any support in these circumstances, despite the gender neutrality of the statutes. But you just flip that one over. Just flip that one over and make it the husband with this kind of money and the wife staying at home, and you wouldn't hesitate to order substantial support to the wife, would you?
The question is, did he do housework?
Malcolm cooks. You cook. Okay. Can we have a show of hands? How many would give support to this poor man for a period of time? See? Times are changing.
There you are.
See?
Would it
We'd
change
cut 'em-
your
we'd cut 'em
opinion
off,
if
though.
if the roles were reversed? Would the wife get more than the husband? I mean, would you give a woman support as opposed to the husband in this circumstance? Okay, would you time limit it?
Yes, limit it to his lifetime.
I would only time limit it if he only got $300,000
Right.
out of these many millions. But if he got $1 million or more in terms of capital out of it, then I think that any support probably would be subject to variation, and a variation application brought after 3 to 5 years to ask him what he was doing to contribute to his own support
There'd be a
would eat
review.
away gradually at
There'd
the.
be a review, for sure.
Yeah.
So there's a presumption in his case, I mean, I get the sense just from the laughter that he was living off this woman, if I could use that phrase. There's something pejorative in the laughter about this man, whereas it may have been a joint decision on their part. She wanted to travel or whatever, and he did that. What's wrong with it?
The assumption is that what she's doing versus what he's doing is exactly what Linda said, that he should. I have a case that is split. And she did do the housework, the gardening, she did it all, and he only had to see her on weekends.
Well, what if they could afford to have all that done for them and she didn't want him to do it?
Well, so what?
You're not specifying the assumption. Well, I think the laughter has to do with the assumption. We're not assuming he did or she did.
Oh, I understand that. That's the point I was getting at. The assumption is that he did nothing. I think that's the case.
Yeah, but so
Yeah.
what? So
Well,
what if that's
that's the
the
next
life
question.
they chose?
Well, this takes us back, if I may say it. We've talked earlier about what arises by the fact of the division of responsibilities during the marriage, and then what duty arises by virtue of the effects of marriage breakdown. I'd like to go back to very, very first principles. What duty arises by virtue of the fact of the commitment inherent in the marriage contract? The I marry you and I will take care of you, or with all my worldly goods I thee endow, you know. Now, I think that we're not talking that word, but there's a marriage ceremony in which people make commitments to each other. And is this scenario really a demonstration of, well, they married, she was wealthy, he wasn't, she had to understand that if the marriage broke down, she would have certain responsibilities, just as in the reverse.
Stephen? Opening comment? Okay. A question for the audience. Do you view, given the Elliott and Moog decisions, and we can ignore Robinson for the moment, do you view the courts as moving toward equality? Equality?
Equality of incomes?
Yes, between
Income
the parties.
equality. Yeah, you think so?
The answer is no?
Yes.
Yes. Do you see that move coming forward, that women and children will end up, assuming the resources are available, because we can't talk about compensatory support when people have no money or they're on welfare. I mean, it's a ridiculous concept. But do you think the courts are moving in that direction, yes or no? No? Okay.
Well, they may in a slightly different way. I mean, if you take a situation where, for the sake of argument, a husband earns $60,000 and a wife earns $25,000, total family income is $85,000, there's a couple of kids who are staying with the wife, I think the courts tend, as a very rough, very, very rough rule, to equalize total family income. So they may say, all right, there's $85,000 altogether, half of that is 42.5. The wife is making $25,000 a year, so we'll give her another $15,000 to $20,000, and probably call it mostly child support. Thus, she walks away with half the total family income, but of course, she has the children with her.
So one
No,
person,
no,
one
it's
person
equalizing
gets
in a
half
limited
and three
sense.
people get half.
Yeah, all right.
That seems to be the way it appears to be going.
Yeah.
Okay. When we had our meeting sort of organizing this panel, Malcolm came up with his omelet concept, which I'm glad he didn't forget to mention this morning. What appeared to be the case, the more we discussed these files and fact situations, et cetera, was that When you get down to the bottom line of the numbers, when the court was coming to the numbers, that the needs and the ability to pay always entered in. That seemed to be the bottom line. You can talk about all the other concepts, but if he can't afford it, he's not going to be ordered to pay it. And if she doesn't need it, she's not going to be given it. She's not going to be allowed to accumulate capital. So I don't think we've come a great distance, quite frankly. I think we've gone in the glitch of causal connection and terminable support, and we're basically back where we were before, but we have a higher ceiling. I don't, Ichi would comment on that.
I'm not as pessimistic as that. I think needs does drive it. I think the needs test does drive it but needs may be driven by a need to compensate for a longer period of time or at a greater level. I'm not as pessimistic about it as you are.
Nor am I. I think we have certainly reached the stage where our courts are not going to say that a woman who has some kind of career and income has no further need. I think they're going to look at standard of living. I think we're going to see top-up awards and with increasing generosity and flexibility.
You know, the Court of Appeal in Robinson used that phrase and said it was not his obligation to top her income up.
Robinson really can be read, I think, as in some situations saying enough is enough, that's all. I think that may be all Robinson can stand for, is that enough is enough in certain limited circumstances. I'm not sure that we're driven back to entire self-sufficiency or any of that. That's how I see it.
You know,
Okay,
they didn't lean on it in Robinson, but once again, remember, these people had been separated for 8 years by the time the matter came before the court. I think that was an influential
They had a
factor.
fairly short marriage, too. It wasn't a 15-year marriage, I don't think. I think it was short.
Wasn't it 13 years?
12, 13, yeah.
Shorter.
Yeah.
Okay.
I think
we're out
to
of
answer the same question, I think that Creative Counsel should be making the pitch for 50-50 on the income stream in as many circumstances as you possibly can. I think relying on Moog and Elliott gives you the way in to do that, and I think there are cases in which it will happen. I think that in some cases there'll be more than 50%, as in that example where there are 6 children. I think that that woman will get more than 50%. I think that the emphasis on compensatory support now will mean that the decisions will be higher in amount and for longer periods. I really think that the termination date in Robinson is an anomaly, or maybe that's wishful thinking.
Thank you, panel. We'll be back here at 2 o'clock, please. It will be very interested, all of us, I'm sure, in the judges' symposium that will carry on the discussion that the panel began, and it'll be interesting to hear their views. So see you all at 2 o'clock.
Anyone for omelets?
2 o'clock?